You want to walk away with at least $1 million. How much do you actually have to settle your case for if you want to walk away with $1 million? Would you like to know the answer? Come join me as I sit here enjoying a beautiful view as I'm waiting for my wife on the beach, as I'm enjoying my beautiful breakfast. And now I want to share with you that information. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I'm having a fantastic breakfast of Greek yogurt with fresh fruit and some honey, and it is absolutely delicious. I highly recommend it. All right, so now here's the question. There have been some clients who turn around and say, you know what? I want to walk away with X number of millions of dollars. I know that there are different fees. I know that there are different expenses that have to be repaid. But how much money do we have to settle this case for in order for me to walk away with $1 million? So in order to answer that question, we have to do some reverse math. If, for example, you were to settle your case for $1 million, you don't actually get that $1 million. Would you like to know why? I'll tell you why. You wind up having to repay your attorney all of the expenses that he has paid out on your behalf to prosecute your case. That amount of money gets repaid to your attorney immediately after you settle your case. Of the remaining amount of money, now the attorney's fee is calculated. And I will tell you, in a medical malpractice case in New York, the attorney's fee is less than in a straight accident case or personal injury case. And it's based on what's called a sliding scale, which means that the more money we are able to recover for you, the less the attorney's fee. As we go up in the amount that we recover, the attorney's fee gets smaller and smaller. So the attorney's fee actually has to be calculated, and it's not like a personal injury case, an accident case in New York, where the attorney's fee is typically a straight 1/3. It is less than that in a malpractice case. Let's say in a malpractice case, the attorney's fee winds up being 20%. So you have the expenses that are repaid to the law firm first. Now the attorney's fee is calculated on what's left. And in this instance, it's hypothetical. It's 20%. And now you're saying, okay, I get the remaining amount. Well, maybe yes, but then again, maybe no. If you are a Medicare recipient or a Medicaid recipient, now you will have to negotiate with either one or both of those agencies. Why? To try and reduce the amount of money that they are claiming has to be repaid to them for all of the medical care and treatment you receive because of this wrongdoing. They paid all that money never expecting to get repaid a dime. But because you have gone ahead and brought a lawsuit seeking to get money as a form of compensation for all the harms and losses and damages that you incurred because of this doctor's or this hospital staff's carelessness, well, now if you are successful in recovering that money or some money to compensate you, now Medicare or Medicaid turns around and says, listen, we spent X number of dollars to pay for your medical care and treatment. We are required to get repaid. However, we are able to negotiate with them depending upon how much you settled your case for and how much they claim they are required to be reimbursed. So that process of negotiating is known as negotiating a lien. A lien is an agency like Medicare or Medicaid turning around and saying, hey, you guys have to repay us before you, the injured patient, gets a dime. So let's go back to the question I asked at the beginning. How much money do you need in order to walk away with $1 million? So we're doing a little bit of reverse math here. And I'm just showing you what expenses need to be repaid before you ever see a dime. So let's say in this hypothetical example, you wind up getting $1 million settlement. You have to repay, let's say, $20,000 to your attorney for his expenses. And now you've got $980,000 to work with that's left. Your attorney in this scenario will get 20% of that. And before you ever get a dime, let's say you have a Medicare lien that now has to be negotiated and they agree to accept $50,000. And now, what happens to the rest? What happens to the rest is that you will get a check for the remaining amount. Now that amount might be $700,000. It might be $650,000. It might be $800,000. If you know at the very outset that after a $1 million settlement, you're only going to walk away with $700,000, you're now asking the question, okay, what do we need to increase the settlement to in order for me to walk away with $1 million? Well, that assumes two things. One is that your attorney's expenses remain the same. And you should know that as your case progresses, and certainly as you get to trial, your attorney's expenses will dramatically increase. So it might be to your benefit to try and enter into settlement discussions before getting to trial. This way it limits the attorney's expenses to a certain amount as of the time that you're having this conversation with your attorney. And two, you now are assuming that the defense recognizes that your injuries are worth exactly what you claim them to be. And that is a significant challenge in and of itself. Because in almost every instance, even if you were able to convince the defense that you are 100% right, that the doctor and the hospital staff were careless and they caused you significant harm and injury, even if they actually admit that they were careless, the problem now is deciding on the true value of your injuries. That will be the challenge for you and your attorney. They will always dispute the full extent of your injuries. So now, if you believe that you need $1.5 million in order to achieve a $1 million, so now if you believe that you need to settle your case for $1.5 million in order to walk away with about $1 million, now you have to get the defense to recognize and acknowledge that your case is in fact worth $1.5 million. And don't think for a second that if you were to turn to the defense and say, hey, listen, we need $1.5 million to settle this case, that is the proper or correct strategy in order to achieve your goal of getting a $1.5 million settlement. Because I will tell you right now, that is the worst strategy you could employ in order to get $1.5 million. If you were to turn to the defense and now tell them that you need $1.5 million, you know what they would ultimately do? They would think in their mind that that is your initial opening bid. That's your initial amount or your initial demand. And they would only go down from there. So their thinking immediately is, okay, Oginski and his client need probably somewhere between $600,000 to $800,000 to settle this case. With that type of thinking, you will never, ever get to the point where you wind up with a settlement of $1.5 million. So in this scenario, you and your attorney might be better off turning around and saying, you know what? This case is worth $3.5 million, $4 million, $4.5, $5 million. And now, once they recognize that, now your attorney has the ability to come down in small increments. The defense, if they are truly interested in trying to resolve your case, has the ability to come up in increments. And hopefully, at some point during the negotiation process, the two of you will reach some middle ground or somewhere in that range where you think it's acceptable to ultimately settle your case. But if you ask for $1.5 million, you will never, ever wind up with $1.5 million. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.